Good afternoon. This is Anita Casey at the State Bar Center, and I want to welcome our speakers and our participants to today's probate law webinar. We are very lucky to have J.E. White, Chris Winton, and Anna Price as our speakers, all extraordinarily versed and well educated in probate law. The webinar today is for 3 hours of general credit. After the conclusion of the presentation this afternoon, likely this afternoon, but possibly as late as tomorrow, you will receive an email that will give you 3 hours general credit. It is essential that you accept that email. If you let it stay in your tickler system, it will not go on your transcript, so you must accept it. If there is some reason you have to leave for part of the webinar today, you are required to reduce the 3-hour credit to whatever amount of time you actually viewed the webinar, but please remember to accept it. Do not let it sit on your desk. The webinar today is approved only for West Virginia credit. Unfortunately, we don't have the staffing or the financial wherewithal to get it approved in other states, but we have provided sufficient materials that you should be able to submit the information requested by other states. We hope that you are able to do that. Before I turn this over to our first presenter, I want to let everyone know that our next webinar is scheduled for May 6th. It will also be an afternoon webinar from 1 to 4 o'clock. It is being coordinated by our West Virginia JLAP program for Wellness Week, which is actually the week of May 6th. That one will have 3 of what I will refer to as the special credit hours, or what some people refer to as ethics. So if you need 3 hours in one of those special areas, the program on May 6th will be providing those. We are not opening registration yet. I would anticipate that registration for that May program will open in the next week or two, so just keep watching the bar blast. I'm going to stop talking now, and I'm going to turn the program over to J.E. White, who will introduce himself and will give you some great information. Thanks, J.E. All yours.
Thanks, Anita. I appreciate that. And good afternoon. And again, thanks for attending today's webinar hosted by the West Virginia State Bar. As Anita said, I am J.E. White. I'm a member at Jackson and Kelly, and I'm here in the Charleston office. And I'm in the tax group, and my practice is primarily related to tax, trusts and estates, and closely held businesses. I get the privilege today of being the lead-off hitter for this webinar, and we do have some good topics, and my colleagues and I hope to present some very valuable information for you in the probate context. So my topic today, as you see, is probate avoidance in West Virginia. But in order to get there and to start talking about probate avoidance, I did want to take a couple minutes to walk through and kind of give you an overview of the probate process, and then turn into more of the probate avoidance topic. So what is probate? Okay, so before I got on here today, I did Google the definition of probate. And if you Google that, and that's always my kids' answers to almost everything, they just say, well, let's just Google that. And the definition is the official proving of a will. But our definition's got to be a little broader than that. And so normally I like to think of it as the process through which a decedent's estate is administered and settled. And so, as all of you know, most likely that there is no probate court in West Virginia. So where does probate jurisdiction lie? And it is found in the county commissions and the West Virginia Constitution, and then West Virginia Code, there it's listed 7-1-3, talks about jurisdiction as well. There are some related jurisdiction sections in the code if you practice in this area, such as 4137, where courts of equity can construe wills. 5513-1 at SEC is the West Virginia Declaratory Judgment Act, and then 5122 talks about general circuit court jurisdiction. So the first question that always comes up when you're dealing with a probate matter is where does it happen at, or where do you go to probate? It's normally relatively easy to determine because most of the time it's going to fall right in here in the code section and under subparagraph A. So it's the county court or county commission shall have jurisdiction of the probate of wills in the county where the testator at the time of his death had a house or known place of residence. So if you live in South Charleston, then you're going to probate in Kanawha County. And so that's relatively easy, house or residence. And then you fall down to B, if there is no such place, it's where any real estate devised is situate. And then you would fall into C, where's the county where the decedent died or any property is located, and then down in your catch-all there in D. So again, it's normally easy to determine where you're going to probate after somebody passes away. West Virginia probate has two systems for proof and allowance of claims. There are basically two code sections that you have to walk through and analyze with respect to each county that you find yourself in. 44.2-1 are the counties, and they're the predominant counties. There's, there's 55 counties. I think there's about 45, 46 of them that are fiduciary commissioner counties. And then we have, and I sit here in Kanawha County, and we are a fiduciary supervisor county. And so I think at last count, there is at least 9 counties that have adopted the fiduciary supervisor system. Even though there may only be a couple of systems, there are really a lot more than that because every county does certain things differently. So you always have to really, talk to them and figure out where you're at and how they're going to handle any issue that may arise with respect to your estate administration there. First, who handles the probate process? The code defines that person as a personal representative, and there's the code section that talks about that. When you're drafting wills, most people generally refer to that person that's going to handle the process as the executor or executrix. If there is no will and you're in this situation, then it's going to be what's called the administrator or administratrix. But every estate, the bottom line is every state, whether there's a will or not, needs a personal representative, and that person's going to kind of be in control throughout the process, and who's going to receive the assets and garner the assets and pay debts and claims and ultimately get the assets to where the will or the intestate statutes say they're going to go. So when you get the call and you need to figure out, well, how do you really probate? And so what we like to tell people is, look, we have to get the death certificate. So that's one necessary item, whether or not you are in a testate or intestate situation. And then you have to take the original will if you're in a original will plus a codicil if there is a codicil. That's always interesting because there is a provision in West Virginia that says you have to probate within a reasonable time, but there's also another code provision that talks about a person in possession of an original will needs to deliver that will to either the county commission or county clerk's office or to the named executor within 30 days. There's a small penalty there. It may even be denominated as a misdemeanor. I've never seen anybody prosecuted thereunder. But those are two things that you're always looking for. Also, I say affidavit of heirs. That's really one of the things that you're going to get once you qualify. There's going to be an affidavit of heirs issued. But really what you need there is going to be the names and addresses of all beneficiaries under the will. And then you always have a checkbook. There is a fee to qualify and to have this process through the county commission. And, so you always have to take that. In West Virginia, that's not a significant expense. So, and it's always important though to tell people that you've got to take that. And then a bond, if not waived. Most wills drafted these days waive bond. Occasionally you'll come across one that does not. But then if you are over on the intestate side, you do have to arrange for bond to be there when, get the paperwork done generally in advance, and then when you can go, your client can go and qualify. And when they do that, they're going to come out of there and, with their letter of administration and the affidavit of heirs and so forth. Another thing that you obviously need will be, your name and address if you're trying to qualify. They generally like to see a photo ID and all that, which will be included. Something else, if there are more than one executors named, a lot of times somebody may be out of state, may not want to serve, and they may decline. So you can do a declination or a renunciation and just, kind of say, I don't want to do it. And that will allow the other named person to proceed with becoming qualified. On the intestacy side, 4414 talks about who that person is. So if you have a will, they're going to be nominated in there. So, I nominate Chris as my executor, and I nominate Anna as the successor. And so Chris would be handling these things on the front end. But when you have an intestacy, you don't have that. So the 4414 will tell you, it kind of gives you a pecking order, so to speak, of who the person will be. And so really within the first 30 days from death, it's to the distributees who apply therefore. And then the number one person is the surviving spouse. Then it drops down to and gives a little bit of leeway to the county commission. And it says such other persons as the clerk court deem fit. And so, there might be 3 children and you might, have that going on. And then after 30 days, the code provides that anyone can go qualify and become an administrator or administratrix. Even a creditor can do that. And sometimes that's what we call the race to the courthouse, at that time. So enough of that. Let's move on to how you qualify. And so the code does lay out what you need and the timing for it. But one of the things that I like to tell people is always call whatever county you're dealing with to verify the process. Especially this really came to light over the past year because we really saw some differences in how the different county clerk's offices were handling qualifications with the COVID-19 out there. Sorry about that. Okay, and so I like to say call, and then because there are, like I said, there are differences. For example, there are counties that were continued to handle the qualifications during COVID in person. They've always been in person. We have that you always have to come in and qualify, even if you're a non-resident, you come in and qualify. Then you can do pretty much everything else via mail, but you do have to come and qualify. So there were counties that continued that long-standing process. However, there were some exceptions, and there were counties that said you still have to come in, but you need to call and schedule an appointment. You couldn't just show up or walk in. And then there were other counties that even today still are continuing to allow qualifications by mail. And what that was, that's basically, for our clients, we'll gather all that information in the prior slide, get it all together, package it up, send it over there. They process it and send back the letters of administration and whatnot. And then we have to forward it to our clients to sign. And then we send it back. And it does take a little more time to handle it in that way. But for a lot of folks, they felt safer doing it that way. And in a couple counties, that was the way you had to do it. So this slide, I'm not going to spend much time on. This is a slide that I think Anna's going to talk about pretty in detail coming up. But once you qualify, so you go over there and you qualify, you're going to need to fill out a Form 601 and a 602. And they're going to tell you, they're going to give you the booklet and tell you you have 90 days from qualification. The appraisement of the estate is recorded and will become a public record. Along with the will. The will is also a public record. But 602, and it's kind of going to be a segue here shortly into the non-probate side, it is filed with the clerk, but it's not a public record. Okay, so, and again, these are due within 90 days. You can generally get an extension if it's needed. As long as nobody's jumping up and down or complaining or anything like that. Really what we do, or what I do, is simply write a letter and say, we have some difficult to value assets. We have closely held business interests we need to get a valuation for, and I need a 60-day extension or a 90-day extension. And then you tickle that, and they have to go back and ask for another one depending on the circumstances. So, but typical probate assets, and these are things that everybody's familiar with. These are things that are only in the decedent's name. So these are the assets that are going to be listed on the 601, tangible personal property. And what we're talking about there is clothing, jewelry, guns, collectibles, vehicles, things like that. And then real estate. And real estate includes mineral interests, and sometimes that gets missed. But stocks and bonds, bank accounts, notes, accounts receivable, business, closely held business interests. So those are the things that are in the decedent's name, and Anna's going to spend much more time on that than I just had. So let's turn now to non-probate assets and really look at what are we talking about here. Okay, so these are assets that generally pass by contract or some other means. So they're not passing under the will. And these are the more common types of non-probate assets, and probably the most common type is joint with right of survivorship. Okay, and then there's payable on death or transfer on death. And I'm really just going to list these now, and then much of my talk later on is going to come back into these in a little more depth. Annuities are part of that. Retirement plan assets, life insurance, and assets that are already moved and in irrevocable trust. So these are the assets that can pass some other way and really don't fall under the probate of the decedent's will, back to the Google definition, but these are still part of what most people view to be their estate. So there's this issue out there of what most people think. And if you ask most people, when we meet with them the first time, we'll kind of say, well, give us a list of your assets or tell me what they are. And they list everything. And then you have to go back through the list and say, well, how's this titled? How's this titled? Because they list everything. Everything they have an interest in, they list. And so, but very importantly, and a lot of people just simply do not understand this, a lot of clients, and really, it is these assets that we just talked about, joint assets, payable on death, and so forth, they're not governed by that will. Okay, and this is where a lot of times you run into some issues. So I go back to the thing that titling of assets certainly makes a difference. So again, non-probate, I'm gonna take a quick diversion over into the estate tax world. I'm not going to stay there long, but anything you have an interest in included in your gross estate for tax purposes. If the taxable estate, if you have a taxable estate, and we know that the current exemption as it sits right here today is 11.7 million. I started practicing in '94, and the exemption back then was $600,000. So it has increased significantly over time, and there's a lot of chatter out there right now, and a lot of the election or the debates and everything pre-election, where what both parties philosophy is there. So there is some possibility that this may be falling back, but it hasn't yet. And so this is where it stands as we sit here today. And going back then to, what most people think to be their estate, whether or not it's subject to probate, but the Internal Revenue Code, Section 2031, talks about, and it kind of has this over-encompassing concept that the value at the time of your death of all property, real, personal, tangible, intangible, no matter where it is part of your gross estate. And so that's where you are in the tax world. And then 2033 pins it down a little bit more and talks about, well, it's only to the extent of your interest therein at the time of your death. And so those are some of the Internal Revenue Code provisions that would be talking about how to bring things back into the estate or include in your estate. So now I'm going to take a few minutes and walk through a very common technique, and everybody is familiar with it. It's joint tenants with right of survivorship. Okay, and the most common assets that we see titled this way are real estate. I mean, a lot of people, me and my wife have our house titled joint with right of survivorship. And so real property, bank accounts. Me and my wife have our bank accounts titled joint with right of survivorship. Or maybe I need to ask her whether or not that's true. But anyhow, that's a very common bank account. Investment accounts are similar. If you have an investment account, you'll see this occasionally. And particularly, with first marriages and all of that. And then the other common one is vehicles. So these are really where we see the bulk of joint tenants with right of survivorship. But sometimes we've also seen issues with respect to joint with right of survivorship accounts. And so I just threw this in here. It can be litigious. And in fact, it is probably the most litigious aspect in estate administration. Now, you run into all kinds of problems, but this seems to be prevalent out there. And let me give you a couple real life examples of where and what I'm talking about. And because, why something as simple as a joint tenant with right of survivorship account can become a problem. So let's say, for example, you have a husband who has a second wife, a new wife, and they have a child, or he has a child from the first marriage. So we only have 3 players here, and he has $1 million. Now, absent any prenup or anything like that, he goes to the lawyer and he says, look, I have a new wife. I want to take care of her. I have a daughter from the first marriage. I want to take care of her. And I've got $1 million. I want to leave half to the new wife and half to the daughter. Okay. Pretty simple, straightforward. And so there you are. But commonly what you'll see is somehow or other, when that person dies, after you did this nice will that clearly sets it out, and that was the intent at the time, a year or two or a week or two, you see all kinds of things out there, but somehow or another, when they die, the bank account, lo and behold, is titled joint with right of survivorship with the surviving spouse. So obviously, in that scenario, the surviving daughter from the first marriage is not going to be happy and is going to want to look at the circumstances surrounding how the bank account was retitled as joint with rights of survivorship. So that's one relatively common problem that we see. The other one is an example, and we probably see this even a little more than the other one, but a mom's 85. We have a local daughter. We have a couple siblings. One's in Texas and one's in Florida or wherever. They're not local. So the mom goes to the lawyer and says, everything I want to go to my kids evenly in equal shares. And so he drafts the will and it says everything in thirds. And so lo and behold, after death, we find out that the local daughter, the one that is taking care of mom, is the only person. It's a joint account and they're the person listed on the account. So brother and sister obviously aren't happy in that example. And so sometimes you'll see different scenarios under which that can arise. But the biggest problem, I think, with joint tenants with right of survivorship and some of those examples, and there are times that there are no issues. I mean, let me say that for sure. But these come up, and the presumption in West Virginia is going to be a gift to the survivor. So that's what causes the problem. And so I have had a few clients that ended up joint with right of survivorship because mom or dad put them on there. And they say, no, that's really not what was intended. And I'm going to throw that back into the probate estate. But a lot of times people will say no. I mean, you give them the advice, this is West Virginia law, and they say, well, that's what mom wanted, that's what she did. And, but the problem is, mom might have went to the local bank and the bank and just told the girl at the bank to say, I want to add daughter on the account so she can sign checks. And they just check a box, joint with right of survivorship, or they may ask, I don't know what those conversations are, the details of those conversations, but somehow or other, it comes out of there, joint with right of survivorship. If you're going to do that, we normally like to say, look, make sure that account is for convenience only, or you're just a signer on the account and not a owner of the account. Because those are, again, I'm going to repeat myself, it's probably the most litigious aspect of the state administration that I've seen. And versus or. Wow. Now, these are 3 or 2 letters that can make all the difference in the world. West Virginia Code, West 36120, subparagraph B, talks about when a title document, whether it's tangible or intangible or personal, whatever, if it links multiple owners with or, then it's joint with right of survivorship. And so all of us on this webinar today have had that question, and versus or. I mean, somebody calls up, he's your buddy, he says, well, here's what the account says, or I'm looking at the statement and it doesn't say, or it says or, and they ask you that specific question, or a vehicle title or something like that. So it is important, and you go back to titling and the fact that a lot of people don't really understand exactly what they're doing when they just title something in that way. So I'm going to move on to the next section, and that's non-probate real property, some of which would fall under the joint tenants with right of survivorship. But this is something that it is common, and you do list that's on Form 601. So that is not the non-probate slide or the non-probate form. That is on 601, which is the probate governed by the will document that you have to file if you're an executor or administrator. But they have to track it here because I mentioned that the 601 is a public record. So in order to transfer and track ownership in real property, we've got to list that on something where there is a record of where it's going. And so probably the most common type of this property is number 1 there. So these are the questions actually from the 601 form. Did the decedent own an interest in real property as joint with right of survivorship? And so if you fall into any of these 6 bullet points, you do have to answer 5 questions. And those questions are going to be, hey, what was the type of the transfer? A deed joint with right of survivorship. Who's the name of the person who it transferred to? And that's going to be my wife, Rhonda. And then the third question is going to be, well, what's the relationship? And she's the surviving spouse. And then what's the value? It's $200,000. And then what's the description? And The description, personally, I like to throw in everything. I mean, I'll list the street address, but then I'll follow that with a whole, everything that's on an assessor's tax ticket, I'll follow it in there. I want to make it easy so that they can clearly see what exactly is being transferred by that document. And so you'll see a couple of the other ones. Bullet point 3 talks about if you've moved it already to a rev trust, and bullet point 6 talks about transfer on death deed, which Chris is going to talk about, I think, later on here in a little bit. So the next type of asset that we're going to talk about is life insurance. Okay, so life insurance, everybody's familiar with that. And normally it's a contract between a decedent or an owner and a life insurance company. And normally you'll have in a life insurance contract an owner, an insured on whose life is insured, and the life insurance company. And so, and that's just a contract. I mean, if anybody watches the ID channel and crime shows, we watch some of those sometimes, and you'll get 50 minutes into one of those hour-long shows on, somebody killed their spouse or something like that. And you'll get 50 minutes in, and you'll see it comes out that, oh, so-and-so had bought a life insurance policy, had been purchased on the decedent's life. And then, of course, they subsequently, or they, I guess, kind of lead into, well, that person killed them for the life insurance money. And so it pays to the list of beneficiaries. And the list of beneficiaries are set out by the owner, and they are on the life insurance contract. And so the owner can say, and they have the right to change the beneficiaries.
JR,
Yes.
You're taking a breath. I'm going to take advantage of it. I have a question. When an individual who is a JTROS on a bank account, say a daughter with mom, are there tax consequences if the daughter gifts the account to the estate or to her siblings, if over $15,000?
Yeah, that's a good question. And what I would say is no, there's not. I see the issue, but I like to just throw it back into the estate and say it was just mistitled. And what the questioner is asking is, are they making a gift? Because there is the presumption under West Virginia law that they're doing that. One other thing, I mean, you could look at a disclaimer, but that's not going to work if that person has children and might not throw it back. So I'm going to say no, but it is something certainly to spend some time on and determine. But I like to say it was just mistitled, and that it is not it was not meant for it to be a joint. It was a probate asset, and there was just mistitling at the bank. Okay, so let's move on now to the next type of asset. Again, very common. Most people have these types of assets, and we're looking at pension plans, IRAs, and so forth. And as everybody knows, those are contracts as well, and they pay to designate a beneficiary. So similar to the life insurance talk that we just had, these are going to pay to designated beneficiaries. And there were some pretty significant changes in the past year or so relating to the Secure Act and the CARES Act. But I'm not going to divert over into that, but I am going to mention one thing. The Secure Act in December of 19, did change the law with respect to what most people refer to as the stretch IRA. And it is a big change in that what happened was you could normally, for example, if I passed away and I have 4 children and their ages are 30 to 20, they could all each choose to take their quarter in that asset and have it payable to them over time and over their life expectancy. Now that was pre-Secure Act, that they got, a significant 50-year plus ability to divert those assets, let them continue to grow tax deferred, and take out the minimum every year. And that's been changed. And now it is severely compressed, and they need to take it out over a 10-year period. So that's really all I want to say about the Secure Act, but that was a big change. But it didn't change anything as far as moving it from the probate, non-probate side to the probate side. So payable on death or transfer on death. These type of accounts, I mean, I've been coming across more and more of them, it seems like. And so there must be somebody out there that's pushing these pretty significantly. But it's similar to the joint account, but it is different. And so, but there are code provisions that deal with it. The bank account is going to be 30, this code provision that I've cited, investment accounts right there. And just a sample of what we're talking about there, that code provision right there, 3610(9) sub A, it says a transfer on death resulting from registration in beneficiary form is effected by reason of the contract regarding registration between the owner, and it's not testamentary. So this is for an investment account, but and then you have CDs. And importantly, again, I'm going to go back on what I've already said a time or two. These accounts, if you do it that way, if you set up your bank account, if it's in my name, and then I go to the bank and say, I want to put POD to my 4 children, then they don't get it, and they don't really have a right in it, and I can use it, do whatever I want to with it. But on my death, it goes to them by virtue of the POD contract, rather than by virtue of my will.
AE, another question. Is it a good time to give it to you?
Yes, let's do it.
If the decedent is a remainder man of a life estate, and there are several other remainder men, siblings, can a creditor put a lien on the decedent's remainder man interest? And if so, how long is that lien permitted to remain as a cloud on the title of the property?
Okay, well, again, that is a good question. And I'm actually going to defer and let Chris answer that, because I think he's going to talk about life estate and remainder deeds. But, there is an interest there that you can put a lien on, or can tie it up in some way, shape, or form. And one of the things which I'm actually going to talk about here in a slide or two is a disadvantage of a life estate remainder deed. But I do think that question falls right under Chris's topic. So I'm going to let him handle that one. And so, and actually okay, so So my next slide is the transfer on death. And again, this is Chris's topic. Well, it's part of his topic. He's going to talk about all real estate transfers in West Virginia. But the Uniform Real Property Transfer on Death Act was enacted in 2014. So we've lived with it now for about 7 years. The decedent can do various things if they own it, and then it's transfer on death. And Chris will walk through the ins and outs of that. But they can sell it, they can mortgage it, they can use it as collateral, and so forth and so on. But upon death, it does transfer to the beneficiaries by virtue of the deed rather than the will. And so this is again, and then now we're going to talk about the last the big picture items that I named. I think I had 6 bullets. Assets moved to a revocable trust pre-death. And so we do a lot of this type of planning, and it's pour over wills into revocable trust. And the gist, revocable trust actually originated a long time ago, really in, I believe, Florida and California were the first states to start using them. But the issue there is cost and complexity of the systems they had. They have in those states, they have complicated probate courts, and they have high fees related to probate. And so in order to avoid the probate courts and to avoid the fees, people, they developed these revocable trusts, which they moved it over, and then it became a non-probate asset, not really subject to those complexities and costs. And so the gist of it is if it is moved pre-death, it's non-probate and private. And so you've got this revocable trust. It sits over there. It's really a private document among the family, but it's not a public record. And it is not subject to or really involved with the executor or administrator's powers to handle under the will. And so that, the privacy issue is a big issue in West Virginia. I mean, the non-probate is there. We don't have the probate court. We don't have significantly high fees, but a lot of people don't want everyone in the county or state or whoever to know what they have. They like to be private, and if you're concerned about privacy, you need to go this route, perhaps, and then have it private, and then you do have to report it. Again, the administrator or the executor has to report it on the 602, but it is a private document and it's not a public record. So everybody in the county can't go down there and look at it if that in fact happens, which some people think it really does. And I've had clients do that both ways. Most of the clients want privacy and they don't want anybody to see. A couple of clients have said, look, I think people think I have money and I want them to know I have money. So they may set up the revocable trust, but they don't move it. I don't necessarily like that approach, but we always have to listen and kind of go through with the client and then or finally go with what they want to do. But if you have a revocable trust, if it's formed and not transferred, then you list it on the 601. And okay, so you list it on the 601, even though it pours into the trust after administration. And the reason for that is because at the time of death, you have to list assets at fair market value time of death, and because they owned it in her or his own name at the time of death. And so good trust planning, however, gets you the opportunity to do some things that you may not be able to do with the other non-probate techniques. It gives you that privacy, and then it also protects assets down. So you can protect your assets downstream. So this can give you creditor protection for your children. This can give you predator protection. They're relatively easy to administer right after death. A lot of times people are their own trustees, and then upon death, there's a successor trustee nominated. That trustee just picks up, it continues right on. And then you can also protect, and you can virtually draft various things into your trust, but you can protect those assets from spendthrift kids, people, drugs, alcohol abuse, and things of that nature. Some other types of non-probate assets that are listed on the form that I rarely see these would be power of appointment, certain gifts, joint right of survivorship property. Annuities are more common. I think I had them on the other slide. And then life tenant of personal property. So where do you list these non-probate assets? Again, if you have the non-probate asset, you have to answer those questions. Those questions are on form 602, type of transfer, jointly held bank account, name of person with an interest, my wife Rhonda, relationship to the decedent, surviving spouse, market value of the debt, $10, description of the property, bank account X at blank bank. And that's kind of what you're going to list in that. So we've talked a lot or went a little deeper with respect to certain non-probate transfers. So potential advantages of non-probate transfers are going to be immediate liquidity. And this is one that you hear a lot. I mean, on a joint account, you can just simply put somebody on a joint bank account. They have complete access immediately upon death. But I'm going to show you a couple of disadvantages here in a minute, and which kind of plays against that. But immediate liquidity is certainly one. I recently had a meeting with a person that had lost his wife. His three children were there. And so we have this family meeting. And during that meeting, we get into the assets. And he had a pretty significant account at a brokerage facility and a pretty significant bank account. And so when he said those, we're like, well, okay, how are those titled? And he said, well, the funeral home director told me that after wife's death that I needed to add, let's just say Jimmy. So he had titled and the account joint tenants with right of survivorship with Jimmy so that they would be able to help him pay bills or whatever. So, we discussed it then and there, and they decided to do the Rev Trust, and we moved it and got it taken care of. But that's an example of somebody out there, giving some advice. I mean, this was 3 million plus, so it would have been a tremendous fight if it hadn't been addressed. And
J.E., this is Anita. I'm sorry for interrupting you, but I wanted to let you and everyone know that the Unlawful Practice of Law Committee has been having problems, at least for the last 14 years, with funeral directors giving probate information. So that is something everyone should be aware of, should talk to the county clerks, the circuit clerks in your area, to let them know that when somebody comes in to ask questions, send them to a lawyer. Do not send them to the funeral home people.
Very good advice, Anita, and that's great to know. Not only do they give advice, as I just suggested in my example, but they also sometimes help and facilitate walking through. They'll take people and do the 601, 602 kind of as part of their deal. But back to the advantages of non-probate is the ease of administration. It is relatively easy to go down there and do that, go to the bank, have the bank change the title card, and there you go. It's simple. Kind of the same analysis of the ease. It's private. It's not reported in public. Even all of those or all those non-probate assets that we've talked about are private. So you don't have to do the revocable trust solely for the privacy because they're not shown up anywhere else. There's just some disadvantages that we're going to see here in a minute. And I see I'm down to about 3 minutes. So I'm going to go ahead and wrap this up. But it avoids probate. So, again, probate in West Virginia is not that complex. It's not that costly, but a lot of people want to avoid it for various reasons. So some of the pitfalls that we see occasionally that you run into on non-probate transfers, and obviously these pitfalls are going to depend on the type of non-probate asset that we're talking about. Abscond with funds. Okay, so let's run back to my example of that meeting I had when this person lost his wife and the 3 kids were there. He had already put son on the account. So this is pre-death. Not only is there going to be the potential issue post-death, but there's also the ability for that son immediately, I mean, the next day, to go take the funds or take 100,000 of the funds. And so that on a joint tenants with right of survivorship account, that's a big issue. The possibility of taking some of the monies may allow creditor access. Similarly, if that person had a creditor, now we've exposed some of that to a possible creditor action because son was on the account and dad didn't really have any creditors. So that's there. And again, that's really a joint with right of survivorship issue. Importantly, from what we do day in, day out, it may vary from the will trust provisions. We've got to figure out really the intent and what they're trying to do and what they're including in their view of the estate, and then figure out how they're titled and how best to handle it. We talked about the examples of the new spouse and the child, or the 3 kids and 1 being out of the estate. It really can affect what's going on there. It may make a later transfer more difficult. And this goes back to the question, one of the questioner's questions, or something like a life estate remainder deed. If I have the deed in my name, or if I have the deed in, or if it's a life estate remainder deed and I want to do something with it, now I've got to get, my kids. I may put my kids on there as a remainder beneficiaries, but now if I want to, sell it, I've got to get everybody to sign off on it. And then you've got always potential issues with non-probate type assets in divorce situation. Might make an asset subject to the divorce, or we've probably all had this scenario happen where I'm not a family law lawyer, but I have taken calls where so and so's getting divorced, or I just got filed, served with the divorce papers, and the other person has emptied out the joint account. And so that's always an issue, whether it be one way or another. Okay, and so I do have, I think, a minute or so left, or Anita can tell me that. And
Jay, I've got two sets of questions, and I know you're not going to have time to do them.
okay.
So what I'm going to do is I'm going to send those two sets of questions to you, and while the others are speaking, maybe you can respond to them. And if you think it's something the group might know, let me know. And then maybe if we have a quick break while Chris or Anna is getting ready, maybe you could respond to those, but you and I can talk about that offline. I am going to ask you if you can wrap up in the next 2 minutes so we can get Chris on.
Yeah, well, I'm actually finished. Yeah, so I've walked through everything, and unless there is a question for the greater good, I'll certainly look at your questions as you forward them on to me. And so whenever you're ready, Anita, you can move right along to Chris.
Okay, well, I'm going to do it right now. Thank you, J.E. You either did a really good job or a really bad job, because I've got these we get a lot of questions. So it's either a really good job or a really bad job, but I thank you. I'm sure it was excellent. Chris Winton, I'm going to ask you to go online, introduce yourself, and take over for the next 50 minutes. Thank you, sir.
Okay, hello, this is Chris. So first I'm trying to get the screen sharing up. Okay, I hope my screen is up now. Hi, this is Chris Winton. I am attorney practicing in Charleston. I'm happy to be speaking today. I am currently the chair of the West Virginia State Bar Probate Committee. We are a very open and active committee, and I would encourage those practicing attorneys and the occasional accountant is also welcome to come and join our meetings and give input in this fascinating area of law. And my topic today is on deed choices for West Virginia real estate. Now, when I was preparing for this presentation, I ran into a cartoon in the newspaper, which was almost perfect as a lead in to my topic. And I say almost perfect because I would need to edit it a little bit. Because of copyright laws, I can't share you the visual of the cartoon, but it's a Peanuts cartoon. And in the cartoon, Linus and Charlie Brown were relaxing outside along the brick wall, as they usually do. And Linus turns to Charlie Brown and he said, "I've decided how I'm going to make my fortune. I think my future lies in sports." Charlie Brown looked back at Linus and said, "Oh, you think you can make a lot of money by becoming a professional athlete?" And Linus's response was, "No, a knee surgeon." And it was almost perfect, but I would want to edit it. And I would edit it to read, "I've decided how I'm going to make my fortune during this ongoing pandemic. I think my future lies in sports." And Charlie would ask again, you think you can make a lot of money by becoming a professional athlete? And Linus's response would be, no, an estate planning and probate attorney. We've seemed to have a little bit of demand for our specialty during our current pandemic. It's kept us rather busy, and it's been a good thing too, because it's helped focus us on aspects of our practice. And one aspect of our practice, which I want to share and we'll be talking about today, is what do you do with real estate in an estate? We do have various choices for doing a deed in West Virginia. But real estate is really a special asset. It's something that our clients generally always own. You know, they may not have a stock or a brokerage account, but they generally always have a house. And the thing about real estate, including your house, is you've got transaction costs to maintain them. You have to pay real estate taxes, probably want to keep it insured. If you're going to be living there, you're going to be paying utilities, and you just need to maintain it, fix it up all the time. And not only just holding it does it cost you money, we also have transaction costs if we want to do a transfer. And that's where we attorneys come in, and that's in doing some type of deed to move it from person A to person B. And when a client has multiple intended beneficiaries, it's not often easy to divide something such as land, or more particularly a structure like a house. So with all this extra baggage, what's an attorney to do when we're advising our clients and how to treat and handle their land? And this is typical what I get in my practice, practically once a week. Clients or potential clients call us up and they say they have a deed and they want it to be changed. And the secret of real estate practice for us attorneys is it's really easy to do a deed. Get the old deed that already exists, retype it, change the names, and you're done. That's a mechanical process. Drafting is easy, but deciding whether you should do the deed in the first place and how to do it right so that it's going to serve the client and do what the client wants, that's not quite so easy. And that's the art of lawyering. I find in my practice, when we do get these phone calls from our clients, wanting a deed, it often takes as long to meet with them, discuss with them, and counsel them on whether to do the deed and how to do the deed as it does just to get it typed up and then executed and recorded. So the theme here is we need to encourage all you attorneys out there to be the attorney, to act like the attorney. Don't be the blind typist that does simply what your client wants to do. And and on these phone calls, our first response to the client is, why are you doing this deed? What's your goal? There are multiple goals that the client has in wanting to redo a deed, whether it's the house, a vacation property, an old farm, or excess property land that the client owns. What's the client's goal? And there could be multiple goals the client wants to serve. Are they trying to reward some family member, such as a child that's taking care of them? Do they want to avoid probate because of the potential benefits of doing that? Are they trying to save some taxes? And of course, taxes, that's a bad word. It's a very naughty word because there are a lot of different types of taxes. Some we can easily avoid, others might not be so easy to do that. Are there liens out there or potentially future liens, such as a government or Medicaid lien that the client wants to avoid? And these are all in the fact situations for our clients that they need to explain to us. And then with that, we as the lawyers need to take it, apply our knowledge of what the law is in order to serve them. So the concept here is there are choices. There are several different options in how you do a deed in West Virginia. And what I'm really trying to focus in on here is transferring a client's house from the older generation to a younger generation. You know, estate planning is focusing on transferring assets. And generally what's happening is an older person who has a reduced life expectancy is going to tend to die first and want to pass it to younger family members. So that's what the main focus of this entire topic is. You know, how do we transfer from the older generation to the younger generation? Now, with all these options you do on making a deed to transfer the client's property, you know, there are different legal effects that are going to flow, and those effects are going to apply to the grantor and the grantee. So there are two sides to the coin that comes when we do a deed. And when we're talking about transferring a house, I've organized these materials to analyze 9 different effects that happen from a deed. And I've also identified 10 different deed choices. So 9 effects and 10 deed choices that are commonly used here in West Virginia. So the goal here is to educate practitioners that you take these effects, you look at them to your client's goal, and with that, you can determine and decide what's the best deed choice to serve your client. So what are these 9 deed effects that I'm going to talk about? Okay. Number 1, the simplicity in creating it. You know, how difficult is it to do a deed? Is it something unusual? Do we have other ancillary type documents to go with the deed? Is it a probate type transfer or a non-probate type transfer? And that follows up from J.E.'s discussion in his presentation. You know, there are certain benefits we want through probate. There are certain detriments in probate, and there are certain benefits and detriments in non-probate. So whether the transaction is probate or non-probate, that effect can be important on our client. Is there a recordation tax? This is the excise tax that applies here in West Virginia for the privilege of transferring real estate. And although the counties have various options now under the laws to apply local deed excise taxes, in general, we're looking at $5.50 per thousand in value for a tax on the recordation of a deed. So it's relevant in planning with a client. Does the excise tax apply? Will we need to pay it? And if we have rather valuable property, we could be running into thousands of dollars of a tax. Ad valorem taxation. It's a different topic, but it's going to affect your clients when you're doing a deed. And maybe it doesn't have too much of an impact here in West Virginia, but the topic is the homestead exemption. West Virginia is not particularly generous in its homestead exemption in taxing the real estate owned by senior citizens. Although your clients are going to think it's very important because they're not going to want to pay extra tax on just simply owning their home if they can't avoid it. And the homestead exemption here in West Virginia cuts off $20,000 in value on the personal residence. So it's important to know if doing a deed transfer, are we going to affect the ad valorem taxation and potentially increase for many years to come in the future the annual real estate tax? Are there gift or estate tax consequences in doing the deed? And now maybe this topic is not so controversial or exciting nowadays with a very large exemption against federal estate tax. As J.E. has pointed out to you, it's currently $11.7 million per person. But there are still taxable clients out there that need to and are concerned about the estate and gift tax consequences on doing a deed. Now this deed effect, the income tax basis, now that is going to affect everyone in the transaction. And the main concept there is there a carryover tax basis, which could be very low to go to the transferee, or is there a stepped up basis to current fair market value? Generally, if we're looking at a carryover basis for income tax purposes, somebody's going to be paying capital gain tax. That's not going to be avoided. If because of some estate tax inclusion upon death, we get a stepped up basis, we can generally avoid capital gain income tax. So income tax needs to be considered in the transaction with a deed. And what is the level of the control that the grantor is going to have in the property? And again, especially if it's their house, they want a place to live for the remainder of his or her life. And if something potentially goes wrong with the transaction, or if circumstances in the family change, we need to consider, is there flexibility that the grantor who owned the property retains in order to undo it, to change it to something better? So a level of control and flexibility of the grantor is an important topic we need to look at. And related to that, it's the other side of the coin, what's the level of risk to the grantor? Because we've done a deed and now an interest in real estate, and especially a house, is now vested and held by other persons. Because we've done the transaction, has the real estate been put at risk from debts or transfers done by the younger generation? And related to the effect 7 and 8 is, and this is a hot topic with for elder law planning. What's the level of Medicaid protection in number one, the deed ownership, and number two, if we're doing a transfer? The basic concept here for Medicaid planning is that the personal residence, the house, of the Medicaid applicant is an exempt asset. It doesn't count. If a disqualifying transfer is done, that can be a very bad thing in taking an exempt asset such as a house and now make it subject to a transfer penalty. And for the transfer penalty now under Medicaid law, we're looking at a 5-year look back period from when the transaction is done. That is going to mean when that deed is prepared, signed, and recorded. So as you may have picked up, I've mentioned that there are 10 potential deed choices in how a house is held or transferred here in West Virginia. And I hope I have time in the presentation here because there's actually an 11th deed choice. I've personally never seen it used here in West Virginia. It's potentially invalid in West Virginia, but I will mention it if I have time in the presentation. Okay, so what are 10 ways we can hold the house here in West Virginia? Well, the first option is the deed's already in the senior's name, just leave it there. In other words, don't do a transfer, just leave things alone. That's a choice, that's an option, and often it's the right option. Our second choice is, well, let's just do a deed of gift, transfer it to a child or children. You know, that's a transfer without any compensation. We can do a transfer and create co-ownership in the deed with the co-owners being tenants in common. We can also create co-ownership in a deed and have joint tenants with right of survivorship. And that is one of the most common ways real estate is owned here in West Virginia, especially between spouses. But you'll notice on my choice here, or for a deed with joint tenancy with survivorship, I put a parenthetical, that is with equal shares. That's usually what you're going to see. But there is the potential to do the deed, have joint tenants with right of survivorship, and have unequal shares. 2 people don't have 50-50 equal shares, or 3 people don't have 1/3 equal shares. The legal life estate. We've had some questioning about that in J.E.'s presentation. This was the very common 100 years ago, 200 years ago. Not quite so common today, but it still has importance and validity and is still a very valid option for deed planning in West Virginia. And we can do a deed, create a non-probate ownership in the real estate, and park the title in a revocable living trust. And a companion to that, if the trust cannot be revoked, if it's irrevocable, the deed can be done to that type of trust. And that is a valid choice in doing the deed, and it can have benefits. The 9th type of deed choice is, let's convey it to a business entity. Let's put it in a corporation, a limited liability company, maybe a limited partnership, maybe a general partnership. That's a valid type of a choice for holding the real estate in West Virginia. And the last, this is a more popular method nowadays, and we've only had it now for a couple of years since the legislature passed the Uniform Act, and that's a transfer on death deed. And we are doing quite a few of these now in my practice. Now you do have rather lengthy written materials for this seminar, and the way my materials have been organized, I do have a master chart which identifies these 10 types of deed ownership. And it breaks down in columns the 9 potential effects for each of these types of ownership. So that's the chart. And after the chart in your materials, I do have sample deeds in blank, which are samples of all these types of ownership. Well, with the exception of the outright ownership, because if we just leave it alone, we're not doing anything. So that's what you have in your written materials. There are, and we do know from requests and what the attendees of these seminars want. They like forms. They like sample type documents. So you've got a fistful of them today.
Chris, I have a question for you. When we have a deed being transferred from parent to child, where no consideration of value is listed on said deed, what value does the grantor report to the IRS? This assumes that value of said real estate is worth more than $15,000.
Okay, that's a gift tax question. That's tax reporting, and under the gift tax law, a transfer without compensation, it can be a taxable gift and a reportable gift to be filed on Form 709. There is an annual gift tax exclusion. The IRS does not want to be bothered by all kinds of gift tax reporting on small de minimis gifts. The gift tax exclusion right now is $15,000 per person per year. So that's the threshold. So if a deed of gift is done, and you've got samples in the material, and I'll talk about those, we've got a question of fact. Okay, if I want to give it to my son, I'll just do the deed. It'll say deed of gift. I'm going to recite that it is a gift and it's a transfer from a parent to a child. I'm not going to be worrying about the excise tax. I'm going to have completed the gift. I'm not asking for compensation. The deed on its face is not going to show the fair market value. But for IRS gift tax reporting purposes, I need to know that value. If it's more than $15,000, I can and should report it on Form 709. It's up to me to determine the value. How do I determine the value? What do I think the property's worth in the marketplace? What value would I put on it? If I'm doing a very tax sensitive transaction and planning for a client, I'm going to go and hire a real estate appraiser and get a written appraisal report in order to document it, in order to report that to the IRS. But the simplistic answer to the question is you get to put your own value on it. You're supposed to get the right and true and proper value, and how you do that can be variable in the circumstances. The highest level of action you're going to do if you've got a risky transaction that might be complained or audited by the IRS, you're going to want to hire a real estate appraiser and get a valuation on that. Okay, I've got 10 types of deeds to explain to you, and if I've got a little bit extra time, I'll explain type number 11. So outright ownership, this is a valid thing to do, which means don't do anything, just leave it alone. And this is frequently when we get calls from our clients, I need to do a deed. We often can talk them off the ledge and say, you don't need to do anything. Things work well right now. Okay, so how complex is it? It's really easy because we're not even going to do anything. We're just going to leave it alone because we've reached that conclusion to leave it alone. In this regard, we're going to be doing and following the Hippocratic Oath, which is first do no harm. If we haven't done anything, we haven't done any harm. Is it a probate or non-probate transaction to leave the deed as it is? No, still owned by the senior citizen. When the senior citizen dies, it's a probate asset because we haven't altered anything on the deed. We're not going to be worrying about the excise tax to record a new deed because we're not doing a new deed. On the ad valorem taxation, there's no effect. The taxation isn't being altered. If our client is age 65 or older or disabled and they qualify for the homestead exemption on the real estate, it's still going to remain there because we've done nothing. Are there estate or gift tax consequences? Well, we're not making a gift. There's no transaction being done. The senior is going to die owning the real estate, and that's going to be included in his or her gross estate. What's the income tax basis? Once the owner dies, it's included in the probate estate, so we get a stepped up basis at death. And of course, where's the transfer occurring here? Transfer is going to be occurring under the decedent's will, or if the decedent had no will, through intestacy. But at least the recipients, whether it's a spouse or children or other family member, they get a step-up basis in the property. So that's valuable for your income tax planning. What level of control does the grantor have? Rate control, because the grantor hasn't given anything to anybody and has simply maintained sole control. What level of risk does the grantor have from the children or other family members in the lower generation? Well, there's none, because the other generation has received no interest. Okay. What's the level of Medicaid protection here if we leave the deed alone and the property is owned by the senior citizen? Well, it's pretty good. If we have the house, it's a personal residence, it's an exempt non-countable asset. Although another proviso and comment we need to make for Medicaid planning here is estate recovery. If our client here retains ownership of the real estate and has serious health problems, needs long-term nursing care, and applies for Medicaid, the ownership of the house will not disqualify him or her because it's an exempt non-countable asset. However, if our client qualifies for Medicaid, the government pays the long-term nursing care bills, our client dies subsequently, still owning the house, it's a probate asset, and West Virginia estate recovery can kick in. The Department of Health and Human Resources can claim a state recovery lien. And so that is a risk. That's what many of our clients that are senior citizens are going to want to look at, to plan for, and otherwise attempt to avoid. Okay, the next type of deed ownership here, and this is what our clients are generally saying. They're calling up and saying, I need to deed my house away. I need to deed it to one or more of my children. And that's relatively simple. We know how to do deeds of gift. They're commonly done. Okay. Is it a probate or non-probate transaction when we do a deed of gift? We're going to create a non-probate situation. How are we creating a non-probate situation? because the real estate's no longer owned by its former owner. It's now out of his or her estate. Is there the excise tax to record the deed? Well, we have an exemption in the statute if the conveyance is going to a child or a grandchild of the grantor. And also the legislature several years ago modified this exemption to be a child and the child's spouse, or a grandchild and the grandchild's spouse. So the in-laws are included in the exemption. So generally that's very useful and helpful to us, because it means we don't have to worry about the valuation of the real estate and report and get and essentially have a toll charge here to get it recorded and transferred to a lower generation, to a child or a grandchild. Okay, if we do the deed of gift, what happens to that homestead exemption? Well, if senior citizen's going to convey it to a person that's not a senior citizen, we're going to lose the homestead exemption. So that means the annual real estate taxes are going to go up. Okay, estate or gift tax consequences. We've talked, a bit about this. If we do the deed of gift, we have made a gift, potentially reportable to the IRS on the gift tax return, Form 709. It's a completed gift. It's removed from the gross estate. Okay, what's the income tax basis that flows from doing this deed of gift? Well, unfortunately, there's going to be a carryover basis. The basis in the hands of the grantor is going to carry over and be the same basis that the grantee on the deed receives. And we're going to have to assume here that the grantor has a low basis because the property may have been acquired many years or decades earlier and has appreciated in value. So doing a deed of gift, we're potentially facing an income tax penalty by way of capital gain. What level of control is our client going to retain when they have gifted the property away? Well, none, because we don't own it anymore. Don't have any legal rights to it anymore. Do we have a level of risk to the grantor from the children who now own the real estate? Well, yeah, we've got a pretty big risk, because the children are now the owner. So what does that mean? Those are some of the risks, like J.E. was explaining, with a non-probate type of ownership. If we do the deed of gift to the child could sell the property, mortgage the property. If the child is not up and current in paying his or her bills, there could be creditor claims filed and liens that are going to be on the real estate. So there is a pretty large risk in doing a deed of gift to our client. Okay, what's the level of Medicaid protection? Well, don't get a whole lot of Medicaid protection if we have gifted away the property, especially if it's a house. Okay, we've taken a non-countable asset for Medicaid purposes and transferred it away. Well, when that happens, we've got a transfer penalty we're looking at. We've got this 5-year look-back period. So, the counsel that we need to do at a minimum with our client who wants to gift the property away to a child, especially if they're elderly and at risk for serious health problems and have high probability of later applying for Medicaid. Do the deed of gift, it's fine, but stay healthy for 5 years. Stay out of a nursing home for 5 years, because the look back period is here. We're triggering that, and that's going to be putting you at risk. So those are the aspects of a deed of gift. Now, some good things in it, but some potential problems that flow with it. Okay. What about a transfer of tenants in common? Okay. Mr. Jones can take his real estate and transfer it 50% to himself, 50% to his child. And they'll own it as tenants in common. Of course, the aspect of tenants in common means that the undivided share of the property owner is inheritable and descendable. Upon death of a co-owner, that co-owner share will pass in accordance with that co-owner's estate documents. So there's no survivorship here in the tenants in common. And here, here's the trivia question. If you've noticed from my presentation materials, I've got photographs and graphics for you. On this topic of tenants in common, I simply have a photograph of a bird. And if we have a poll, maybe someone could tell me what the bird is and why it has to relate to tenants in common. And I'm giving you 2 seconds. It's up. The bird you're looking at is called the common snipe. And yes, there is a bird called the snipe. And not only is a snipe an existing bird, they're also rather common. Hey, but back to doing deeds. Doing a deed, putting some other fractional owner on it as tenants in common, very easy. It's commonly done. Do we have a probate or non-probate transaction if we do a tenants in common deed? Well, we've got it split. The grantor has retained an interest, hasn't given that away, so that's still in the probate estate. Grantor has also given away a fractional interest, like a half share, and that's a gift. And that gift is going to be non-probate. Is there a recordation tax? Just like the deed of gift, we have an exemption if we're doing a transfer to a child, grandchild, or a spouse of one of those persons. If it's to some other person, we need to recite value on the deed and pay our excise tax. What happens with the ad valorem taxation? Okay, we've put a second or third or fourth owner on this deed, and they own it as tenants in common. Well, to the extent we still have a senior citizen who's living in a house that can be, and the homestead exemption is preserved. What are the estate or gift tax consequences? It's just the same, basically, from our deed of gift. But what's happened here, we've only made a gift of a fractional share, a partial share. So if we have a $200,000 piece of real estate and we've put a child on it as a co-owner as tenants in common, that child now has a 50% interest, and we've made a gift of a half value or 100,000. So at least for gift tax purposes, we've reduced some of the reporting on it by the fraction, because we still retain something. Okay, what about the income tax basis? Just like the deed of gift, we have the same results follow, but we've split what's happening here. The grantor retains something, dies with that, we get a step-up basis. The gift basis, we're going to get that carryover basis, which means we've got a potential issue with capital gain plan. What's the level of control for the grantor? Well, it's moderate because the grantor still has a deed interest, but now someone else owns it. So that means we've got a stronger measure of risk here, because other people, being a child generally, owns a share. So we have risk from their creditors, their conveyancing. What about Medicaid protection? It's very similar to what's happening with a deed of gift. If we're retaining a house, we got a non-countable asset, but now the senior doesn't own the entire property. Senior has made a gift, so we're looking at a potential transfer penalty. Although, as I said before, instead of transferring the whole property, we're only transferring a fraction of it. So the value of the gift for the transfer penalty is reduced, at least by a fraction. Okay, this is more commonly what we're going to see here in West Virginia for a deed choice, and that's joint tenants with right of survivorship, and we're going to have equal shares.
You were saying?
It's very easily done. And you've got two options in order to draft the deed here too. When I started practice many years ago, we would use straw deeds. Our client would convey to a staff member in the office, and always someone who was unmarried, because we didn't want to worry about any spousal rights. But the client would convey to a staff member in the office who acts as a straw party. That deed's recorded, and then the straw party immediately signs a deed conveying the property to our client, and the second, third, fourth owner of it, and the deed recites as joint tenants with right of survivorship as at common law, and not as tenants in common. That's the magic language. And so that is what is commonly done and popularly done. Those were straw deeds, but we do have in the statute the right to do a conveyance directly from the grantor to himself and the other party, creating survivorship because it's statutorily allowed. And in your materials, you have samples to do that. Is it probate or non-probate? We've got a non-probate provision here. Do we have to worry about the recordation tax? Again, the theme keeps coming back to who do we give it to? If we're going to make a conveyance to a child or grandchild, we're going to claim the exemption and not worry about the excise tax. Ad valorem taxation. If the senior citizen still owns the property, the homestead exemptions, they're still intact. What are the estate or gift tax consequences? It's essentially going to be similar to the effect of tenants in common, except here the entire interest on the property is going to be included in the gross estate when the grantor, who again we assume to be the senior citizen, dies. And what that means with its flowing income tax effect is we could get a stepped up basis in the entirety of the property because we've done joint tenancy on the deed. The level of control of the grantor is moderate because we've given a share to somebody else. So we got the risk of somebody else. And that risk is coming from the child who now owns a share. What happens for Medicaid purposes, again, the house is a non-countable asset, but what's happening here too is we've made a gift of a share. So we're looking at the transfer penalty that can kick in, and then that's going to put us in that 5-year look back period. But this is commonly done a deed joint tenants right of survivorship. But that was with equal shares. So here's the next choice. And that is, I've done a few of these in my career. I've run into a few of them in the record room, but they're not too common. These are used in other states, and that is a deed to joint tenants with right of survivorship, but the shares are not equal. If there are 3 people on a deed, we assume that every party has an equal 1/3 share. These are called lion cub deeds. And that's why you've got a graphic here of the mother lion and her cub. In a lion cub deed, the senior citizen will own a large percentage, 98%, for example, and 2 children will each have a 1% interest. And why would you do this? Well, it's the value of that transfer of a share. If we transfer 100%, we've got 100% value to report. If we transfer 50%, we've got 50% of value to report. If we transfer 1%, well, the numbers are getting down low. They're getting workable here. So that's the concept of these deeds. Okay, are they simple to create? No, they're moderately complex. They're not too common here in West Virginia. In fact, there are some potential arguments that since West Virginia recognizes the aspects of the common law on joint tenancy, one of the common law required unities is equal shares. You've got a potential violation of the common law here. But when West Virginia legislature passed the transfer on death statute in 36-12-15, there is some language which was specifically included to attempt to validate these types of deeds, because you will run into them because of the potential benefits here that attorneys were seeing and recommending to their clients.
Chris, it looks like you took a breath, so I have a question I'm going to submit to you. If using a straw deed rather than a direct transfer for JTROS, does that subject the transaction to recordation tax?
No. Okay, because we're still going to put the recital in there that if it's going to a child or grandchild or a spouse of one of them, we're going to claim and be eligible for that. And that's what we do if the transfer is going. It's that last paragraph before the signatures that says, the parties to this deed under oath state that this transfer is exempt from the excise tax because of blank, and then we fill in the blank, and the recital is because it's conveyance to a child, to a grandchild, or one of those. If we don't have that to recite, then we can be looking at paying the excise tax. So if you do a lion and cub deed, that shouldn't affect the homestead exemption because the senior still owns the property. The estate or gift tax consequences, well, you're going to have a gift here, but it's going to be a reduced share or fraction. But the one benefit we're getting here is still, if the senior citizen dies, we've got a stepped up basis because the entirety of the property is going to be included in the decedent's estate. And we get a little more comfortable with a lion cub deed because well, we've given a share away, but it's a smaller share. It's not as large, but we still have this risk from children because they've got a vested property right. And for Medicaid purposes, and this is why people were doing these lion cub deeds, because they wanted a non-probate asset, which is what the survivorship does, but they didn't want to create a big transfer penalty. So the position is, I have a $100,000 house, I conveyed away a 1% interest in survivorship to a child, so I've only made $1,000 gift. I can live with that penalty. I don't want a $100,000 gift. I don't want a $50,000 gift. $1,000 gift with a 1% conveyance out, I can live with. That's why people were doing these. And I think these were pretty common in North Carolina. Anytime I've dealt with one, it's because I've been contacted by a North Carolina attorney who said, my North Carolina clients got real estate in West Virginia, and this is what we want to do. Okay, legal life estate. We can still do these. You know, they're commonly done. They're a little more complex in doing because we're going to reserve a life estate. And the issue we need to get into, people, when you're drafting these deeds, make sure it's very clear that the remainder interest is vested in someone. It's vested because the remainder men might die before the life tenant. A remainder interest in a life estate is a transferable interest. It's an inheritable interest. It's a descendable interest as long as it's vested. So make sure it's vested because people might die out of order. The remainder person might die before the life tenant. So it's a little more complex in doing. Okay. This, of course, is a non-probate transfer. Is there a recordation tax? Again, here we come back to the theme. If we're targeting the transfer to a child or grandchild, we're going to have this exemption. Ad valorem taxation, you know, we like this component. It's really nice, okay? Because if there's a life estate, senior citizen still has possession. The homestead still applies. Okay. Is there a gift and estate tax consequences? Well, we've made a gift here because someone gets a remainder interest. Okay, now note that that gift is a gift of a future interest. The remainder grantee on that deed cannot get into possession and use it today. That's a future interest. And under the gift tax laws, a gift of a future interest is not eligible for the $15,000 annual exclusion. So a life estate deed is subject to a gift tax, which means your $11.7 million exemption is going to be eaten into. The life estate is good. We like it because it's included in the gross estate. If we've got it in the gross estate of the decedent, then for income tax planning purposes, we've got a step up basis of the entire property on death. So that's good. We like that. What's the level of control of the grantor? It's pretty good. Why? Because the senior has possession. The senior has a vested interest in the entirety of the property and can't be dispossessed. But, and this was the question to JE, we still have this issue. So we have a child can have a vested remainder interest. So if we're doing a life estate deed, we're going to have a conveyance to a child. If that child now has a vested real estate interest in West Virginia, which is, as I said, transferable, inheritable, and descendable. So that means if that child has creditors and they file liens against that child's name, those liens can and do attach to the vested remainder interest. Okay, what good is that remainder interest? Well, if I'm a really mean creditor, I could try to foreclose my judgment lien and seize that remainder interest and get it sold. Who's going to bid on that at the courthouse steps? Not many people. So a remainder interest can be subject to a lien of the child. So that is a risk. It's kind of a reduced risk because most creditors may not figure out that it's owned. may think that it's exempt. And if anything, the life tenant's not going to be dispossessed. So that's a level of protection. Okay. What's the issue with Medicaid protection with a legal life estate? Well, we get some partial protection. Okay. Our client still owns a home with a life estate, and so that's exempt. But we've got the 5-year transfer rules, which are going to kick in. And so we're going to have to look at the value of the transfer, and we're going to look and use the Department of Health and Human Resources actuarial table to determine what that penalty transfer is. Okay, let me try to collapse these a little bit quicker since my time's running a little bit shorter here. We can do a deed to irrevocable living trust. Okay, it's a little more complex because we're going to do a deed to the trust. Of course, we're going to have a companion document, a trust agreement. And good practice is we need to do a memo of trust. And I do have a sample of a memo of trust. The reason we want to do a memo of trust is because we need to tell the world in the public records who are the trustees. If this named trustee is deceased and can no longer serve, who's the successor trustees? We like to have that in the record. That's what the memo of trust does. So we've got a non-probate transfer with a trust transaction. Do we have a recording tax on this? The statute's a little bit fuzzy. I haven't had a problem claiming an exemption for a transfer to a trust without consideration. I haven't had any clerks call me on that. It's a little bit vague in the wording of our statute. Ad valorem taxation, if it's a revocable living trust, the homestead should apply. I mean, this was an issue, decades ago. We often had to wrangle with the county assessors that this was a house. It was deeded in a revocable living trust. It could be revoked by the grantor, and it was still eligible for homestead exemption. That's kind of cleared up now, and we don't see that issue arising. The homestead can apply. Okay, let me skip these. If it's a revocable trust, it's not a completed gift. We've got it included in the gross estate. We're going to get a step-up basis at death on the property. The level of control of the grantor, that can be pretty good, because if the grantor is the trustee's one controlling it, not the children. For Medicaid planning, there's no protection because it is a house. It's a non-countable asset, and we still have a potential estate recovery that can apply on it. Okay. The flip side of the revocable living trust is, well, what if we make it irrevocable? It can't be changed. Okay, well, we've got to create all these documents, companion documents, so it's a little more complex. It is a non-probate transaction. We're going to be claiming that exemption. The ad valorem taxation is going to be similar to the revocable living trust. State or gift tax consequence, that's going to be highly variable. What are the terms of the trust? Do we have a completed gift? Is it included or excluded from the gross estate? So that's going to depend on what we're doing in the trust. And the income tax planning, whether it's a carryover basis or stepped up, it's going to, again, depend on what's in the trust. The trust can be very useful because the control is going to be at the trustee. Medicaid planning, we're going to be looking at the transfer penalty. Now, if we're creating the trust as an exempt special needs trust, a D4A trust, then we've got a good transaction for Medicaid planning purposes. Okay, let me just try to finish this really. The deed to an entity, we've got a whole lot of other documents to do. We've got tax issues. We've got registration issues, but it can be done. And essentially what a deed to a business does is it converts it to personal property. The real estate becomes personal property because we're dealing with shares or units. So this is a little more complex. It's not something that we do in the average transaction for a client, because it's going to have to be nursed every year, because now we've got an entity with tax returns to file, annual reports, and it's definitely more complex. Okay, the transfer on death deed. We like these because they're pretty simple. Well, most attorneys now know how to draft them. You can follow the statute. That makes it pretty simple. It's a non-probate transaction, so keep that in your head, because we like that for Medicaid planning purposes. These are exempt from under the statute from the recording tax. The ad valorem taxation, the homestead exemption still applies because we're not doing any transfer at all presently. State or gift tax consequences, no gift is being made. This is still included in the grantor's estate because the grantor can revoke it. It's revocable. And so there's a step-up basis in it. So the income tax consequences are good. The level of control of the grantor, it's really great, because the deed can be revoked at any time before death. Do we have a risk from the children? We have a limit, none really, because the children have no interest. It's not until death. So this has a lot to accommodate our needs of our clients. It's the level of Medicaid protection is very strong because the house is exempt. There's no transfer being made here. And the West Virginia Income Maintenance Manual, that is our state regulations, recognize this now, that it is an exempt transfer. Now, an estate recovery won't apply, except for one exception, and that is estate recovery doesn't apply because this is a non-probate transaction. As long as the state has not filed what are called TEFRA liens. The state can, under certain circumstances, file a lien against a Medicaid recipient before his or her death. If that's done, then the state's got a lien. Okay. I'm not even going to click on my conclusion because I went through that pretty fast, but I think I got it covered. So Anita, if you have any more questions, I got maybe 30 seconds before we probably
Chris,
take a break.
to give Anna an opportunity, I have one question pending and will send directly to you instead of sharing it with the group. I apologize for that. I want to thank you for your presentation. I will ask everyone, we've had over 300 people. We still have 300 right now, which is awesome. We are going to take a 5-minute break. Please keep your video off. Please keep your computer muted. We will be back with Anna Price in exactly 5 minutes. Thanks again, Chris.
Anita, can you see and hear me?
Yes, we can see it.
Okay, great. And you can
Yep.
see my screen?
Yes, we can see your PowerPoint.
Okay, good.
Yep.
Okay, I'm going to go ahead and introduce our last speaker for the day, Anna Price. Anna, I'm just going to turn it over to you to wrap us up for an excellent afternoon so far. And I know it's going to continue with your presentation. Thank you so much.
Thanks, Anita. As Anita said, my name is Anna Price. I'm a partner at Jenkins Fenstermaker here in Huntington, West Virginia. And my practice focuses solely on estate planning, estate administration, some probate litigation, and elder law. Of that, my passion is probably in the estate planning realm, but estate administration is definitely the end result of your planning. It allows you to see how your planning works out in the end. So first of all, I'd like to start out my presentation with a joke to lighten the mood, since what we're talking about is pretty heavy when we're talking about the death of our clients or the death of our clients' loved ones. And so one of the upsides of having Zoom presentations are that you don't have speakers that say good afternoon, and when they don't hear you loud enough, they make you say it louder. So we don't have to do that, but now we do tell jokes and no one laughs. Or if they do laugh, we don't know if they laugh. So I'm going to assume that you think my jokes are really funny. My husband reminds me that they're not, but I think they're pretty funny. So Lenny goes on vacation and he asks his friend Bob to watch his house. A week later, he calls home and says, "How's my cat?" Bob hesitates and says, "Sorry, your cat's dead." Lenny says, "You should have broken the news to me a little bit better. You didn't have to tell me all at once. You should have done it slowly. First, you could have called and said, your cat's stuck on the roof. The second time I call, you could say, I just don't think the cat's going to be able to come down from the roof. I don't think we're going to be able to get the cat. And then the third time I called, you could have said, we tried to get her off the roof, but the cat fell and didn't make it." So Bob apologized. And then Lenny follows up with, "How's my grandmother doing?" Bob takes a deep breath and says, "Well, she's on the roof." So I know that is an off-color joke when we're talking about death, but I know I'm your last presenter before the end of the day, and it's a beautiful day here in Huntington. I hope it is where you are. So hopefully we'll be able to move through this quickly, and maybe that'll give you a laugh later. The first thing I want to do is I want to break down the timeline of the estate administration process. So this timeline is how I explain how estate administration works, not only to my associate attorney, but to my paralegals and to every client that comes in and sets an estate planning appointment. So the timeline always begins with a date of death. That is what throws us into the estate administration process, and that's the date that we work off from initially. Within 30 days of learning the date of death, the person who is holding the original will has a duty to deliver that will to the executor or to the court, which here is the county clerk or a probate clerk. And that's in accordance with West Virginia Code 4151. Once the personal representative is appointed, so that's either going to be an executor if there is a will, or it could be an administrator if there is not a will, or in some cases there is a will and there's still an administrator. But that appointment is going to be pursuant to West Virginia Code 4413. 90 days from that appointment. So the appointment starts a 90-day clock, and 90 days from that appointment is when the appraisement and non-probate inventory forms, or form 6.01 and 6.02, must be recorded. And that's where our presentation, my presentation, is going to focus on that 90-day period. That's what we're going to be looking at today. That's West Virginia Code 44114. Within, after that appraisement and non-probate inventory are filed, there's going to be an advertisement in the paper. Generally, the clerk does this. We have 55 counties here and we have 55 different forms of probate, so it could be a little bit different where you live. But the clerk generally does the publication in the paper, calling for all creditors, and that creditor claims period starts, and it's a 60-day period. It goes from the date of the first publication. So you'll find that in West Virginia Code 41511 and 41512. And upon completion of the administration, so if there are no claims or if you have settled those claims, then the estate can be closed pursuant to a final settlement, which is a full final accounting, or a short form and waiver of final settlement. So that's the timeline that we're working with. Make sure we can. Okay. So we're going to go back to that 90-day period. So the period that starts after the personal representative has been appointed, and they have 90 days to file this appraisement and non-probate inventory form. So generally, when someone comes to me and says, what is the duty of an executor or a personal representative? My short answer is, your job is to gather the assets, protect them, and distribute them according to the document or to intestacy. So the first thing, that's probably the hardest thing, is discovering what assets somebody had if they're not there to tell you what they had. So how do you do that? Well, if it's a former client that has passed away, I always try to hang on to their estate planning file that has their asset information in that file, because I always ask for asset information when I'm doing estate planning. But if you don't have that, if you're not privy to that information, then you're stuck doing some detective work. And my best advice for discovering these assets is interviewing family members, relatives, financial professionals like their accountant, their financial advisor, insurance agents, attorneys, and friends that may lead to this information that the decedent had. Sometimes we have neighbors and friends who drove a decedent to the bank every week, so we know where they banked. Other ways we do this are we find their hiding places. So they may have safe deposit boxes, or sometimes they have lock boxes. There are fireproof safes, etc., that people use all the time to put important papers or assets. A lot of older folks have boxes. Generally, they have colors, it seems like. I'll hear from my clients that everything anybody needs to know is in the red box or in the green box. And so sometimes there are boxes with important papers. Other times there might be a home office with filing cabinets. Other ways we can find different assets, we can look at income tax returns from the past couple of years and see what income producing assets they had. Property tax tickets are always helpful. There is a program in West Virginia called Digital Courthouse that will allow you to look up a decedent's real estate anywhere in West Virginia, taking the information that's at the courthouse, and it's pretty helpful. And the membership to that is not very expensive. So that's a good thing to have if you're doing a lot of administration. Another way is to ensure that the mail is being forwarded to the new personal representative's home so that they're getting every piece of mail that the decedent had. And that may have statements or something like that. Bank statements, or even just information from a financial advisor or someone that they had been talking to. So it can be really, really tough, especially today, because now not only do we have assets that are tangible or assets that are easily discovered with tax returns or information, we also have digital assets. So for a long time, West Virginia did not recognize these digital assets formally, but now we do have a code section on this. And I'm not going to dive into this too deeply because I think that this could probably be a session in itself because it can get pretty complicated. But West Virginia Code Chapter 44, Article 5B outlines the West Virginia Uniform Fiduciary Access to Digital Assets Act. So the code defines a digital asset as an electronic record in which an individual has a right or interest. So it may not include an underlying asset or liability unless that asset or liability in itself is an electronic record. So this could be social media accounts, email accounts, online photo albums, online banking accounts, blogs, digital music, or other digital property that you may have. I am not a technological person. I do the best that I can, but my IT people always know me very well because I need their assistance quite a bit. So these can get very difficult. I haven't had a whole lot of estates with digital assets that have significant value, but there are articles coming out every day with estates that do have digital assets that are becoming more and more expensive and have greater value. So one of the things I can tell you about digital assets is that these could be subject to and are subject to state and federal laws, but also those online user agreements. So every time you click to accept the terms of service and the terms of agreement, you are signing a contract for these assets, and it does affect the access to the assets that there are. So sometimes I have clients that will list passwords, and I still do encourage the transfer of passwords to a personal representative if you truly trust them, because it does make it easier to access those assets, but you could be breaking the law by using that password to access those assets. So be very, very conscious of that for your clients. I do have clients sign a release that authorize their personal representatives to release those digital assets. Sometimes the companies throw it right back and say, we're not going to honor this. And other times they'll work. And I have put a sample release in your materials today that you are welcome to use or tweak for your best benefit. I can tell you that I had a mother of a young decedent who really, really wanted to get access to a locked iPhone for picture purposes through AT&T, and we were not successful there. But we did not have a release like this either, and it was prior to the new law. So there may be better options now, but it was very devastating for her. So like I said, I'm not going to waste a lot of our time today talking about digital assets because they can be very, very confusing and have lots of moving parts. And I haven't seen them make much of a difference in the estate administration process yet. Although I'm interested if J.E. and Chris have had experiences where there's been a holdup in the estate administration process because of digital assets. Okay. The next thing we must do after we have found all of the assets is we need to identify and value these assets. So according to West Virginia Code 44114, a personal representative has to appraise the probate assets and real property. So do they really? Good question, right? So this is, let me go back to J.E.'s presentation from earlier this afternoon, where he talked a lot about probate versus non-probate. I'm going to give you my cheat sheet definitions, which J.E. did a great job of explaining, but just as a reminder, probate assets are assets that the decedent owned in their name alone. They pass through the will or via intestacy. Non-probate assets are assets that pass according to an outside contract or ownership. So they're either a jointly owned asset or they have a beneficiary designated to them. There are some other examples of that, but those are probably the most common. So we're talking about the appraisement, which we haven't gotten to yet, but that's where these probate assets are going to go. So do we really need to appraise every single asset that a person owned before it is listed there? And how do we do that? Well, if the estate has the means to do that, or is required to file an estate tax return, you probably do want to put more effort into appraising all of the assets. So you can hire an expert, and that can be paid from estate assets, and they would make a valuation as of the date of death. But for most estates in West Virginia, we don't file estate tax returns because they don't hit that 11.7 million individual mark, which of course may change at some point. But right now we're not doing a whole lot of estate tax returns. So do you really have to get the appraisal done? Well, I would say a good rule of thumb is if the estate is in some kind of turmoil where there is an action or litigation going on, an appraisal does help unless everybody agrees. Or if you're on that border of those estate tax numbers, that's another good reason. Or if the estate can support the appraisals, then I support the appraisals. But a lot of times, like Chris said, a client may not have other assets. They may just have a home. And so it seems kind of wasteful to have those beneficiaries pay for an appraisal at that point. So let's talk about each individual type of asset. And these types of assets kind of follow that appraisement form. Hopefully we'll have enough time to look at that. But these assets kind of follow that appraisal form or appraisement form, I'm sorry. And there are different ways that you can appraise each one. So for tangible personal property, this one is really tough to value. So this is listed on Schedule B of the appraisement form, Form 6.01. And generally, unless there is an estate tax issue, a detailed appraisal is not required for tangible personal property. Sometimes there are special appraisals required for special tangible property, like artwork, specific collections. We just had one done for firearms recently. Some antiques and collectibles, jewelry is a big one. So those appraisals can be done. For jewelry, we usually find a jewelry store and there will be somebody there that can do an appraisal of that. Firearms, a lot of times pawn shops will have someone, or if there is a firearm dealer close to you, there's a place that I use here in Huntington. They always do a good job and they base it off of a book that reminds me of like Kelley Blue Book for cars, which is how we appraise vehicles generally. So different options for tangible personal property. Your best option is to give a best guess. Much to my dismay, clothing and costume jewelry just don't resell very well. So there is not, it's best to put a nominal value on that because your creditors aren't going to get much from the sale of that anyways. Next are stocks and bonds. And these are listed on Schedule C of your appraisement. So there's not a ton of guidance on the West Virginia appraisement for how to value these. So I always recommend looking at the federal estate tax return guidelines. And they state that the value of securities that are national, regionally, or locally exchanged is the mean of the high and low selling prices and the valuation date. A lot of times you can just get the date of death value from the broker. So that makes it a little bit easier. Depending on what series the bonds are, they may be valued differently. So E and double E bonds are valued by government redemption table. It's updated monthly, and that's available online or at any commercial bank. Corporate stock is a really hard one to value. So we have stocks and bonds, pretty easy to value. Tangible personal property, tough to value, but maybe doesn't matter as much because it's rarely worth a significant amount that's going to change the value of your estate significantly. But corporate stock is a tough one. It's listed on Schedule D of that appraisement. And the appraisement requires that you list the company name, the number of shares, the value per share, and whether the stock is closely held. And then that will lead you to the total market value of the date of death value. So for corporate stock, if it's closely held and it's a family business, we generally recommend a valuation done by a CPA. That can be really expensive. So if it also depends if there's litigation going on with that estate, or if there are people arguing over the values, or if there are a lot of creditors. So sometimes you can do an estimated value. And I really lean on my CPA friends here for this. So the decedent CPA can often give you a really good substantiated estimate that could be easily defended if it's called into question. And you can always amend these appraisements. So if there ever ends up being an issue with that, you can always go back and have it amended so that it does reflect the value if you do get it appraised or valued later. Accounts are on Schedule E of the appraisement. So the appraisement lists money, certificates of deposit, notes, account, etc. This is going to be your easiest one because you're going to ask for a date of death statement from the bank that holds these accounts. And that date of death value is going to be the value that you list. Some of these you have to be careful with because they may be non-probate. So if the accounts are joint or if the CDs have beneficiaries on them, remember that they will not go on Schedule E. They will go on the 6.02, the non-probate inventory. Life insurance. So life insurance is usually non-probate, but occasionally it's payable to the estate, especially on the second spouse to pass. It seems like sometimes the surviving spouse forgets to change their beneficiary, so it automatically goes to the estate. And that depends on the life insurance contract. But we always request a Form 712, which gives you all the information that you need to list that life insurance on the non-probate inventory or on the appraisement. So it will tell you the cash value if it was a whole life policy, the date of death value or death benefit, the accumulated dividends and interest, post-mortem dividends related to the period before death, and returned premiums. So all of that is going to be important information for you to have, especially if you're filing an estate tax return, which we're not really going to talk about today, but you really do need to get that 712 to back it up. A lot of times when clients come to you, they will have already applied for the life insurance. And if they've done that, they'll say, oh, well, we didn't get a Form 712. And I say, well, you probably need to ask for one. They're like, oh, I got the check. And sometimes that's not enough information. So I would make sure that you are requesting that 712. Finally, real estate. So we won't go into this a ton either because Chris and JE both touched on real estate and really did a great job. So you really need to get the deed to determine if real estate is probate or non-probate. Like I said, I use tax tickets to find deed book and page numbers all the time because sometimes it's tough to find the actual deed. Digital courthouse is another place I look for that. They don't pay me for these advertisements, but they probably should. But that's a great program if you don't have it. And it gives you the information that would be on the tax ticket, including those assessed values. So do you always have to have a certified appraisal of the real estate on your appraisement and non-probate inventory? I say no, unless there's a question about it or you're filing that estate tax return or you have creditors. I avoid that. And usually we will go by the golden rule that the assessed value of real property is 60% of the fair market value of the real property. So take that assessed value and understand that it's 60% of that fair market value. And that's what we generally list. You have to kind of watch that too, because generally what you list the real property as on that appraisement, that's how the assessor's office is going to treat your property for moving forward. So if the beneficiaries are planning to keep the property, you don't want to raise the value too much because that will also raise your property taxes. But if you're planning to sell it for quite a bit more, you might want to talk to a realtor and see what their suggested list price is, what the property may sell for. And that's probably what you want to use as your value there, because you don't want to have a significant gain when you do sell it. So it's all about timing there as well. And a lot of times, I mentioned we have 55 counties and 55 forms of probate. A lot of times you will receive some advice on how to list your real estate from your probate clerk or from the assessor's office. And I suggest that, or your clients may, I suggest that you counsel your clients on that because it may not always be the best advice there. Okay. Moving forward, once we have figured out how we're going to value all of these assets on the appraisement, we have to actually report them on the appraisement. So what is the appraisement? And I'm going to show you a copy of an appraisement and show you how I do it if we have time today. And it looks like we're doing pretty good. So the appraisement lists all probate property. And it also lists non-probate real estate. So the only non-probate assets on the appraisement are the real estate. It also lists the heirs and beneficiaries of the estate, which sometimes causes issue if you don't know exactly who they are. But you list these values on the appraisement within 90 days of your date of appointment. It's signed by the personal representative and notarized. And then it is filed with the clerk within that 90 days. And it's recorded in that county. So it is a public record. The appraisement is a public record. It's important because it's prima facie evidence of the value of the property listed. So the personal representative is swearing to those values that they are listing. If they fail to file, the personal representative, if they fail to file that appraisement in a timely manner, they are guilty of a misdemeanor and subject to a fine of $25 to $500. I will tell you that I have never had that experience where that has actually happened. I don't know about JE and Chris. They've practiced a little longer than me, so maybe they've seen something like that. But I will say that I have not seen it, and I have had the same experience as JE, where if I'm going to be late on filing an appraisement, I just call the clerk and tell them we need a little bit extra time. I've never had a situation where they have not granted it. And I always follow that up with a letter to them saying, thanks for the extension. We'll be sure to have it to you. And sometimes we need multiple extensions. So, okay, the non-probate inventory form. These are newer than the appraisement form. So you will see appraisements in really old estates, but you won't see non-probate inventory forms because they just came about in about 2001. And so before that, all of the assets were listed on an appraisement and there was a full disclosure of assets. And apparently that let a lot of people know what assets were there that didn't need to know that, caused a lot of issues with creditor claims. So in 2001, they began requiring the non-probate inventory, and that's pursuant to West Virginia Code 11.11.7. And so now personal representatives are required to file the non-probate inventory, listing and appraising all non-probate assets. So this can be tough for a personal representative, especially with things like life insurance that pay to somebody else, because sometimes they'll call the insurance company and the insurance company says, well, you're not the owner or the beneficiary, so we can't talk to you. You have to show proof that you are the personal representative. So you have to send that letter of administration that you got during the appointment, and that should get you access to that form 712. But it can be challenging sometimes to get, especially non-probate assets or the information that you need for them to list, because somebody else is in control of that asset. Even with joint accounts, sometimes we have trouble because they've already been cleaned out by the joint owner, or with payable on death, they've already been paid out. So it can be tough to fill out your non-probate inventory form. Usually when I'm looking for assets, I don't ask, is this probate or non-probate? I don't ask the financial entity that. I just ask for the ownership information, beneficiary information, titling, and usually I can figure out whether it's probate or non-probate there. That's usually easier than asking them because they may not know. So non-probate assets, of course, include those joint tenants with right of survivorship, real estate options, or sometimes they're jointly held bank accounts, payable on death beneficiaries, remaindermen. There are transfer on death deed beneficiaries. We've already talked about a lot of these today. They can also include powers of appointment. A lot of times we see annuities or property held in trust, gifts that have been made prior to the decedent's death. And there's a lot of different options here, but if it's controlled by an outside contract, that's what trumps. So if you write a will, if I write a will and leave everything to JE, but I title my assets jointly with Chris or list Chris as the beneficiary on everything, Chris is going to be the one that's in luck here, and JE is going to have the will that shows my intent for that, but the assets had to be changed. So when you're doing the estate planning, especially, it's important to ask for that asset information so that you can make those changes to that. So what happens with the non-probate inventory? Well, it's confidential. So it's maintained by the clerk of the county commission or a fiduciary supervisor. I like to imagine that they probably have a room somewhere in the courthouse with locked file cabinets with all of our non-probate inventories, because we never see them again once they are filed. It's completely confidential. They used to be submitted to the West Virginia State Tax Department. My understanding is that they're not anymore. So they go into a hole somewhere in the courthouse, but they are used quite a bit in probate litigation and settling an estate.
Anna, I have a question.
Sure.
How do you determine what attorney fees to charge for completing the estate for heirs?
Well, if you're just doing the general estate administration process, In West Virginia, I'm licensed in Ohio and Kentucky too, and they have some options to take a percentage to determine what the fee would be for, and I'm assuming you're talking about the attorney's fees, what the fee would be for the attorney who's assisting with the administration. But here in West Virginia, I think most attorneys do either a flat fee arrangement or they bill based on hourly rates, which is what I do. I bill based on hourly rates. And I have my paralegal and associate attorney do the majority of the gathering information, because that's a lower rate and that's what takes the longest. So we try to keep it a reasonable fee. I hope that answers your question. If you're talking about the executor fee or the personal representative fee, that's a statutory fee. Okay. With that non-probate inventory, the heirs and beneficiaries do have a right to see that. So if they request that, the personal representative has to produce it. And that's pursuant to Chapter 11 as well. So not much that you can do there. So I'm not going to get into a ton of identifying creditors and what happens with creditors, because that's not really what the purpose of my presentation is today. It's more on that, on the appraisement and non-probate inventory and how you fill that out. But that is the purpose of these documents. The purpose of these documents is to put on record what the decedent owned at their date of death and what creditors can access. So when the appraisement is filed, like I said, the publication is made calling all creditors, and the creditor has 60 days from the date of that publication to file a claim. Additionally, a notice is mailed to all beneficiaries and all reasonably ascertainable creditors. So that's something that you would get from the clerk. They send you that notice, and then it's your job as personal representative or counsel for personal representative to send that out for them. This is what I was hoping to get into, and it looks like we have about 10-ish minutes, is that right, Anita, to go through this appraisement. So at that, I hope you guys can all see this. I had to actually print out a larger one for myself to be able to see, but hopefully you guys can all see, and I can point to what we're talking about on here. But this is the form 601. There's where that number comes up here. And this is the appraisement of the estate for decedents dying after 2001. Keep in mind that 2001 was the year that changed with the non-probate inventory. So it looks a little different. There are, and actually this one is has come from online because that was the best way we could get it on a PowerPoint. But now they have circle options for these, and you will get a packet. Your client will get a packet when they're appointed as the personal representative in most counties. And that packet will include the instructions for filling these documents out and including this packet. So part one, most of the information you're going to have on here is going to be from the death certificate. So you're going to have the decedent's name, social security number, date of death, residence, state, county, marital status, name of surviving spouse. All of that's going to be on that death certificate. If you have a death certificate that incorrectly lists the residents, your issue is with vital statistics or vital registration. They are the ones that will correct a death certificate if there's something wrong with it. And we've had to do that a couple times. It does take a little bit of time. And I will say death certificates are taking a little bit more time than normal right now as well. Additionally, you're going to list the counties where the decedent held real estate, because you're going to put this on record in every county where the decedent held real estate. So this doesn't just go in the county where the decedent was domiciled. That 601, 602 is probably going to be necessary in all the counties where they owned real estate. And a death certificate and copy of the will may also. Will this estate be required to file a federal estate tax return, a Form 706? You're required to say yes or no here. The answer is yes if the decedent's estate exceeded the unified credit amount, which Chris said this year is 11.7 million, or if it is a surviving spouse who wants to use portability to use the deceased spouse's unused exemption. And I promise we won't get into too much of that, but if you have questions on that, let me know. Will this estate be required to file the?
Before you go on, let me ask you
Yes.
a question that just came up.
Sure.
Is real or personal property held JTROS by two people? No, excuse me, if real or personal property held JTROS by two people, do you list value as 1/2 of market value or 100%?
I list the value as 100% on the non-probate inventory. So I assume that the entire account is the non-probate asset. That's a good question though. So that leads right into J here. Will the estate be required to file a non-probate inventory form? If there are non-probate assets, the answer is yes here. If there are not, the answer is no. Did the decedent leave a will? It's pretty self-explanatory. If they did, the answer is yes. If they did not, the answer is no. The fiduciary's name and mailing address is the personal representative, and the preparer is your information. Generally, clerks are pretty good about contacting you if they have questions about it rather than contacting your client directly. Although we have some counties that contact the client and then the client contacts you. But I usually just let them know that we are taking all information for our clients and we're taking all questions. Okay, part 2 is where people start getting really bogged down. So let me make this easy for you. Part 2, I should say part 2 and 3. Part 2 is going to be non-probate real estate. Part 3 is going to be all of the other probate assets. And this section, part 2 and 3, are summaries of the other portions of the document. So Schedule A, and I'm going to flip back and forth here, probate real estate, you'll see down here, Schedule A, probate real estate. So when you list your assessed and appraised values, that total under appraised value is what goes on number 1 in Schedule A of Part 3. Same with tangible personal property, bonds and securities. You'll see that it's kind of following the assets that we discussed earlier. Moving over, continuing Part 4, corporate stock. Remember, we talked about the closely held versus publicly traded stock. Money, bank accounts, certificates of deposit, notes, accounts receivable, etc. Same thing. You're going to list that again back on Part 3, which is going to be your summary. And then Schedule F is all other assets not hereinbefore mentioned, including insurance payable to the estate. So that's like what we talked about with the Form 712s, and any other assets that you have. So sometimes we might have, I'm trying to think of what some of the assets we've had that have gone there. We've had life insurance, of course, go there, and other assets that we haven't had another place for, that they didn't seem to fit anywhere else.
Anna, I have been asked to slip in another question before we let you go.
Sure.
When Form 6.02 has been filed with the clerk and administrator/executor did not retain a copy, what is the process for a beneficiary of the estate to compel the production of a copy of Form 6.02?
Great question. So if the personal representative didn't keep a copy, it's going to be really, really tough. It's going to be different with any clerk that you deal with in the 55 counties, but you pretty much just have to prove to the clerk that you have you're authorized to see it, and they still may not produce it. So you may have to go through the personal representative to then get it from the clerk. So it's really tough. We always advise our personal representatives to keep a copy, but I know that doesn't always help when you don't represent the personal representative. So my advice is good luck and just show them the proof under Chapter 11 that you're entitled to it. And usually you will get some relief there. We have been able to get it before, but it is really, really tough. Okay, part 5 is going to be where you list your beneficiaries and heirs. You're going to have your personal representative sign in front of a notary, and the rest of this is for the folks at the courthouse. This page, page 5, this is where you're going to have your inventory of non-probate real estate, and you're going to answer all of these questions, A through E, the type of transfer. And these questions should be super easy now that Chris has given you his presentation. But if you ever have questions, let us know. Form 602, non-probate inventory, very similar information in part 1. Again, part 2 is a summary of the information behind it. So when you look at this next page, the question number refers to page 1 of the 602, which is, here are the question numbers over on the left side. So you're going to list what number it is with the asset description, and it does give you some information on how you list the description with the market value, and the total value here should match the total value here. So it's a 2-page document. If you ever need more space, just make sure that you're adding another sheet of paper and making it clear what goes with what. But the non-probate inventory is a tough one. One of the things that people always ask me is, I don't know where to put retirement accounts because it doesn't specifically say retirement accounts. And we generally list them with annuities here on 6. So that's where we list them. JE and Chris may list them somewhere else, but that's generally where we list them. And I think I've got like 1.5 minutes to answer any questions that may exist out there. But I'm glad that we got to go through that form. If you have questions, I'm happy to answer them anytime. The forms are what overwhelm our clients and what drive a lot of our clients to us. So it's important that we have the knowledge to fill them out.
Anna, I don't have any other questions pending right now. I want to thank you for your presentation.
Sure.
Very much appreciated.
Yeah.
Let me remind those who are listening, we've had an awesome response today, a lot of good questions.